All right, we're going to go ahead and get started here. Thanks everyone for coming out today and attending. This is Eric from HR Simple. We have Kathy Speaker MacNett from SkarlatosZonarich out of Pennsylvania. Their firm authors the model policies and forms for Pennsylvania employers on hrsimple.com. The presentation today is to be or not to be an independent contractor. I want to give special thanks to Kathy for one. She's out in Pennsylvania, and the folks out on the East Coast, the weather hasn't been good, but she's here today for us. And anybody else who might be attending, we appreciate it. Okay, so a couple quick announcements. Today's presentation will last approximately 60 minutes. We got time for Q&A after that. HRSimple.com is an HRCI approved provider and a SHRM recertification provider. At the end of this webinar, we will give you codes for both certifications to get your credit. We encourage you to enter your questions in the chat box, and we'll address them when we can. A recording and slides will be emailed to all registered attendees after this presentation. We're also posting all of our webinars at youtube.com/HRSimple. Now to give you a quick introduction to today's speaker, Kathy Speaker MacNett, Esquire. Kathy Speaker MacNett focuses her practice on management-side labor relations, employment law, and related legislative and regulatory developments. Her practice combines preventive approaches to labor relations matters and representation of employers before federal and state administrative agencies and courts. Ms. MacNett represents public and private sector employees in a wide range of labor and employment law matters, including workers and unemployment compensation proceedings, FMLA issues, prevailing wage disputes, discrimination complaints, affirmative action audits, handbook preparation, unfair labor practices, and union organizational defenses, and much more. She served as the research director to the Labor Relations Committee and the Pennsylvania House of Representatives, and she is also assistant counsel to the Pennsylvania Labor Relations Board. So without further ado, I am going to go ahead and turn things over to her. Kathy, are you on the line?
I am on the line. Thank you, Eric. Welcome to all who are joining me on this webinar today. I awoke this morning thinking how timely it was. I am located in Harrisburg, Pennsylvania, and the weather jumped upon us 30 inches of snow this weekend. Shortly thereafter, the mayor of Harrisburg announced that the normal municipal crews were overwhelmed, and he was bringing in private contractors to provide additional services for the municipality of Harrisburg. One of the big problems is what to do with the cars. Another big problem is what to do with the snow. In any event, I suspect that a lot of those situations will be contracts between the city and some employer, which is relatively easy, and in those cases it's going to be a service contract. However, it could be a situation in which the mayor hires individuals who are not incorporated, and that leads as a segue into our presentation of to be or not to be an independent contractor. I will mention to you that at times today, and I'll try to make it specific, I will be referring to Pennsylvania law. At other times, I'll be referring to IRS interpretations, which of course is federal law. But when I refer to Pennsylvania law, I'll try to make you aware of that. If you have a situation in another state, you should be sure to make sure that you also check on the law in that particular state, because it could be different from some of the examples I'm giving you under Pennsylvania law. So let's talk about this. Is a person to be hired as an independent contractor or as an employee? That is an issue which has been with me throughout my legal career. And I've come to learn that many other attorneys deal with the same sort of thing. It is a significant determination to make at the get-go, and it's becoming even more critical as we move into some other areas. For example, the Affordable Care Act, sometimes known as Obamacare, triggers when employees are counted. And if you are counting people as independent contractors mistakenly, your count for the Affordable Care Act will be off. The same is true of ERISA and a number of other laws. So although the distinction has been critical in the past, it is becoming even more critical as we go forward in our more complicated society. Let's go into the test that is frequently used by the Internal Revenue Service, the IRS, for independent contractors. When I started practicing, there was a 20-factor test used. Now, after a number of years of practice, they have changed that to a 3-factor test, a test of financial control, behavioral control, and a test of the relationship between the parties. You will see on a number of these slides references to websites which will take you to locations with even further information if you wish to see more, and I recommend those to you for read more about it, if you will. The first test is the test of financial control, and as you can see, we're looking for facts which demonstrate a right to control or direct how the business aspects of the worker's activities are conducted. I caution you that right to control is a very, very key component of the independent contractor relationship. And the right to control is important whether or not it is exercised by the entity which is arranging for the services of the worker, of the person. So whether the employee makes a significant economic investment and whether there's an opportunity for that worker to suffer a significant profit or loss is a big piece of financial control and the financial control test. The second of the tests is the behavioral control test. And there you're looking for facts which demonstrate whether or not there is a right to director control, again, the key language of director control, how the worker performs the service, when and where to do the work, what tools or equipment to use, what routines or patterns to follow, and what order or sequence to follow. And that is basically the behavioral control test. The third prong is the relationships of the parties. And we look to facts. And again, I keep saying we look to facts because all these determinations are highly fact-specific in every state in which they are made, or by the federal courts if the federal courts are making the determination. For the relationship of the party, you're looking to the facts which demonstrate how the worker and the business perceive their relationship. So you're looking at the existence of traditional benefits or written contracts, the intent of the parties, and discharge and termination. So that's the latest 3-factor test used by the Internal Revenue Service. I will tell you that as a practitioner, I believe the older IRS test is the easier of the two to apply. And in my estimation, what the IRS has done is to take the 3 tests that we've just talked about and use them as headings over some of these factors that I'm going to be talking about as we go through. So either way, you should get to the same result, whether you're using the 3-factor test or the 1987 revenue ruling test, which has the 20 factors. I sometimes think of this as my teapot speech or my weight speech. If you think about the old scales of justice, You're basically putting facts on one side or the other, depending on whether or not you believe the person is an employee or an independent contractor under these tests. And you're looking often at what's called the totality of the circumstances. I have, in my decades of practice, yet to find a situation where I could go through and say that a worker met all 20 of these tests, or that a worker had none of the factors in the 20 tests. But again, if you go back to it, the right to direct and control is key. But let's talk about the 20 factors. If the person, the worker, must comply with the employer's instructions about work, that is one indicia that the person is an employee, not an independent contractor. If the person receives training from or at the direction of the employer, factor number 2, that is an indicia that the person is an employee and not an independent contractor. If the person provides services that are integrated into the business, again, that is an indicia, a factor that the person is an employee, not an independent contractor. And let me stop there and tell you about 2 cases that I think are kind of interesting. One of them came from a radio station back in the days when the radio station was still spinning platters or playing records as opposed to digital music. At that point in time, the radio station decided that it would switch from a jazz format to a rock format. You can probably get some idea of the age of the case, because at that point in time, the radio station decided that no one over 50 years of age could appreciate rock music. So at that point in time, they terminated everyone who had been a disc jockey for the station when it was playing the jazz format. The first issue before those employees could bring an age discrimination lawsuit was whether or not the employees were independent contractors or employees, whether or not the workers were independent contractors or employees. So the court looked at that, and the court said that one of the key factors for a radio station was to avoid this. That is dead air, because if you have dead air, then a radio station is not going to get very much advertising, and the radio station is not going to continue. So the services of the disc jockeys was determined to be integral to the business. So integral to the business, and these persons were so controlled, as the court found it, being told what times to be there, what they could play, being subject to then FCC regulations, that in that case, the whole work that these workers were doing was determined to be as employees, not as independent contractors. A second case, which kind of caught my fancy at that point in time, was a case involving a bunch of cake decorators who were not being paid the applicable minimum wage and overtime. And those cake decorators received cakes from a bakery, but then iced them and did whatever else needed to be done to the cakes. In some of the situations, they were told that so many of the cakes had to be anniversary cakes, so many had to be birthday cakes, so many had to be for other occasions. The court looked at that case, and similar to the case that I told you about with the disc jockeys, determined that these workers, even though they were working in their homes on cakes brought in from the bakery, that these workers were in fact employees, because people went to bakeries not just to buy things that tasted good, but also to buy things that looked pretty. So the services, again, were found to be integral to the business, and it was determined that the people were employees, not independent contractors. The fourth of the IRS factors is the worker provides services that must be rendered personally, and if that is true, it is more an indicia that the person is an independent contractor as opposed to an employee. So many times we think of employees as somewhat fungible or interchangeable. In days gone by, if you hired a guy by the name of Red Adair to help you with firefighting, it was because of his personal reputation often that you were hiring him, and he and his company eventually was involved in putting out some of the oil fires in the Gulf. But this is an indicia that the person is an independent contractor, not an employee. The fifth test is to hire, supervise, and pay assistance for the employer. And if that is going on, generally, again, an indicia that the person is an independent contractor, because you would not expect an employee to hire, supervise, or pay people to do the work that you are asking them to do. The sixth factor is whether or not there's a continuing working relationship with the employer. And if there is, that's more of an indicia that the person is an employee as opposed to an independent contractor. Now, there are cases where independent contractors provide services over a long period of time, but by and large, that tends to weight the scales that we're talking about toward an employment relationship. Number 7, if the worker must follow set hours set by the employer, again, indicia that the worker is an employee, and indicia that the employer is exercising some control over that person. Let's look now at what test 8. If the worker has to work full-time for an employer, generally an indicator that it is an employment relationship, because it's uncommon for an independent contractor to work only for one entity. Generally, they hold their services out to the public and work for multiple entities. Number 10, if the work must be done in a sequence set by the employer, generally that is a situation where the person will be deemed to be an employee, not an independent contractor. Factor number 11, if the worker must submit regular reports to the employer, again, an indication that the person is an employee, not an independent contractor. Now, some independent contractor relationships do require a report to be given, but usually the independent contractor is the one that's determining the time when that report will be submitted, not the entity for which the person is performing the services. Number 11, if a worker receives payments of regular amounts at set intervals, you're looking at something that looks a lot like payroll, whether it's hourly or salaried, and you're looking at a factor that leads the IRS to believe that the person is an employee rather than an independent contractor. Number 13, if the person receives payments for business and or traveling expenses, it's looking more like the person is an employee, but I will tell you that frequently independent contractors will also write that into their contracts, so that I have seen that and do not consider that to be nearly as determinative a factor as some of these others are. Number 14, if the worker is relying on the employer to furnish tools and materials, that is an indicator that the worker is an employee. Number 15, if the worker lacks a major investment in the facilities, used to perform the services, an indicator that the person is an employee. And if you think about it, the whole factory concept is based on the fact that the worker goes in and provides a service during a set number of hours, works on materials provided by the entity, works on equipment provided by the entity, and is an employee, not an independent contractor. Number 16, I think, is very similar to one of the others that we talked about. If the worker cannot make a profit or suffer a loss from their services, then it looks like they are an employee. Now, we know any employee cannot work certain periods of time and will lose their salary or their hourly wage or their other compensation, but that's different than whether or not they're going to, in effect, lose their shirt in the situation like an independent contractor could if they, for example, misjudge the project, give a project price, and are then locked into the project price. Coming down the home stretch, number 17, if the person works for one employer at a time, looking more like an employee, again, independent contractors generally hold themselves out to multiple people. Number 18, if they do not offer their services to the general public, that's looking more like an employee. Most independent contractors are going to do some sort of advertising. In the past, the Pennsylvania Unemployment Comp people were looking for ads in magazines or ads in newspapers. Now, more and more, I think we're looking toward the internet and other types of advertising. But if services are not offered to the general public, looks like an employee. If the person can be fired at any time by the employer in most states, that's looking like an employee at will, not an independent contractor. And again, if the worker may quit at any time without incurring any liability other than maybe some notice requirement, that again is looking more like the person is an employee. So you can see that when we go through these factors, most of these look like the employee is, like the worker is an employee. And I should share with you that most agencies of federal and state government tend to look at it the same way. If there is a default, they are going to look at the person as an employee, not an independent contractor. That's generally the way they see it. And often you're in a situation where you're going to have to appeal not only to the agency level, but maybe to a court to get an employee determination reversed, even if you believe that based on the 3-factor test or the 20-factor test, the person is legitimately an independent contractor. Let me also mention that you can treat a person as a part-time employee without any legal problem. If you treat a person as an independent contractor, you may incur legal problems. Generally, as I mentioned in those 2 cases earlier, the question of employment or independent contractor status comes up when a worker is looking for some sort of benefit. Coverage under workers' comp, coverage under unemployment comp, coverage under age discrimination protections or other discrimination protections, coverage under wage and hour. In most states, in most situations, those are limited to employees, not independent contractors. I will add that there are a couple wrinkles on that in Pennsylvania. If anyone is interested, send me an email and I'll be happy to fill you in a little bit more. A note, the 20-factor tests that we just talked about are not equally weighted. Again, right to control is supreme, even if it is not exercised. You should also understand that a person's consent to be treated as an independent contractor doesn't cut it when it comes to the state or federal agencies and the courts. The person does not have the right to waive that protection. And again, the most important of all the standards is the right to control test. Let me share with you one real-life example that came out of a Pennsylvania case. The Pennsylvania case I thought was particularly interesting in that the worker sought unemployment compensation benefits after the company indicated that it was no longer going to work with her. My reaction to this particular case was that if this worker was not an independent contractor, there was no way to have a legitimate independent contractor in Pennsylvania. The requirements were that she have a computer, that she have internet access. She could work from her home, she could work from any other location. So you are seeing that the employer did not control where she worked. The employer did not control when she worked. She could log in, do work, log out. She simply had to let the entity know that she had logged out. She could work tomorrow. She could work a month from now. She could work 2 months from now if she so desired, and the work was online work, which she did. All of the workers for the company were arranged this way, and these workers reviewed professional responsibility testing for teachers and had to give feedback on the tests that were taken, but it was not your standard 2 + 2 = 4. It was the sort of thing where the teacher was asked to describe 3 things in a room that could be used as teaching aids. And as long as they described 3 things, that was an appropriate answer. The local unemployment compensation authorities determined in a very cryptic decision that this person was an employee. We then appealed the case to the Unemployment Compensation Board, wrote significant findings of fact that included the 20 factors for IRS. The board adopted our findings of fact, but still said that the person was an employee. It was taken to the Commonwealth Court, which in Pennsylvania is an intermediate level appellate court, and Commonwealth Court said no, she was an independent contractor, and the case then went to the Pennsylvania Supreme Court, which has the right to either accept the case or reject the case. The Supreme Court rejected the case and basically said that the Commonwealth Court was right on the determination, and this person was truly an independent contractor. The employee was looking for a variety of coverages and still filed a case on other grounds with the federal courts. So you can see how difficult it is not only to determine that someone is a bona fide independent contractor, but also to stop the related appeals that that particular worker might wish to file. Let me move away from the tests and some of the real-life examples and take a minute to tell you that you do have the ability to ask the IRS if a particular worker is an employee or an independent contractor. You can submit information to the IRS. The IRS will answer you on the basis of the information submitted. If the information submitted is complete and appropriate, you can rely upon it. My suggestion to you is that you do that only if you are willing to follow the advice from the IRS. Because if you ask the IRS and do not follow the advice that a particular person is an employee, you are probably in a situation where you have willful violations of a variety of laws rather than non-willful violations. And that can add additional time to the statutes of limitations that are involved and can be a real problem for you. I have, for your convenience, enclosed some material that you'll see on slide 19, or links to materials for the IRS. And if you are looking for additional information, I'd suggest that you follow those links to obtain additional information with regard to the way IRS looks at things. Some of you may remember that independent contractor versus employee became a huge consideration a few years back in a Microsoft case. Microsoft did something which I think is difficult to reconcile with the smell test that we've all used from time to time, in that they hired people to do the same work as their normal employees, to work side by side with their normal employees, and then treated them as independent contractors rather than as employees. If you went into the location, you would have had trouble determining who was the independent contractor and who was the employee. And Microsoft was in a situation where it went to the U.S. Supreme Court. There were something like 11 separate cases involved. And eventually the Supreme Court remanded the case back to a trial court to make determinations on whether or not these independent contractors were really employees to be included within the 401k plan of Microsoft. So this has a huge practical impact as to whether or not you treat people as independent contractors or whether or not you treat them as employees, especially for benefit purposes. So why shouldn't I classify as an independent contractor? It looks enticing on the surface, but you must remember that the classification of an independent contractor saves employers money in that they are not providing workers' comp premiums, paying workers' comp premiums. They're not paying unemployment compensation taxes. They're not paying FICA. They don't have to pay for insurance benefits, or they don't have to have vacation and holiday pay or pensions or 401ks or health care or other fringe benefits or comply with ERISA. All of that sounds pretty good up front, except that government agencies frequently disagree. And those government agencies include the IRS, who we've been talking about. It also includes the Department of Labor. The U.S. Department of Labor has taken a very restrictive view regarding which persons may be considered as independent contractors and which persons may or must be considered as employees. Misclassification is the term that they're using if you put a person in the wrong category. And it's estimated that by the IRS that 94% of all employers out there misclassify some workers as independent contractors when they should be employees. That is estimated to lose something in the vicinity of $2 billion annually as tax revenue. And then you have the problem that the employer has not paid FICA, otherwise known as Social Security, FUTA, otherwise known as the Federal Unemployment Comp, and income taxes. In preparing for this, I've also seen estimates that many independent contractors, even though they are given 1099 forms, do not report all of their income to the IRS. So one thing you will want to consider to hedge your bets a bit is if you are treating someone as an independent contractor, make sure that you do file the necessary 1099 form so that the IRS can at least get in touch with the employee before they come after you as the employer to obtain information. You can see why, with losses of this type, why IRS would be targeting misclassifications. And recently, targets of the misclassifications have come also from the Department of Labor, which is referring to what they are calling a fissured workplace. They don't like it if people think they are employees of a particular entity and turn out not to be employees of that entity. The Obama administration has gone as far as saying that each employer should make a threshold decision before bringing an employee into either status as an employee or an independent contractor, documenting why they believe the person is either an employee or an independent contractor. So more and more, this is becoming an issue. The Internal Revenue Service some time ago developed some safe harbors. I am going to mention this in the seminar because I believe it's important, but I am also going to mention that most of the safe harbors don't protect a lot of the industries and employers that are out there. It's under a particular section of the Internal Revenue Code, Section 530, and it allows certain folks to remain as independent contractors for federal tax purposes under certain circumstances. The problem is, and the reason that it does not apply to many out there, is the person had to be consistently treated as an independent contractor since 1977, which is beginning to be a very, very long time ago. And the employer has to have filed Form 1099s with the IRS since 1978. Again, something that happened a very, very long time ago. And the employer relies upon a reasonable basis, such as an IRS audit, a court ruling, or practice in a large segment of an industry to justify the treatment of the person, of the worker, as an independent contractor. So again, that's something that you should be aware of, but because of all these caveats, these protections do not apply, excuse me one moment, to certain persons who are providing technical services, including engineers, designers, and computer programs, because if you think back to 1977 and 78, we really didn't have a lot of those folks in most industries. Even if a person is properly treated as an independent contractor, the employer must get the person's social security number or face substantial penalties. And again, if there's a social security number, there's a tracking mechanism for the IRS to go back and to obtain information from that person or from the entity that is utilizing the services of that person. The IRS is estimating that the safe harbor applies only to about 9% of those classified as an independent contractor, so you have less than a 1 in 10 chance that the particular employee that you're dealing with is going to legitimately be treated as an independent contractor rather than as an employee. Let's stop for a moment and direct our attention to some of the practical realities that are out there. This is the context in which these cases arise. One can be if a worker is injured and they believe that they are going to have workers' compensation protection. They may file a workers' compensation claim only to find out that you are treating them as an independent contractor. This is one of the results that kind of puzzles me, because from an employer's viewpoint, I would much rather have workmen's compensation protection in place than not. And maybe that's because at one point in my career, I was doing a lot of workers' compensation defense. If workers' compensation is in place, the most an employee can recover is the amount that is allowed by the state law. Most state laws for workers' compensation provide some percentage of replacement of the person's wage or salary, and many will also provide medical benefits. And although that may sound expensive to you, workers' comp originated to do away with tort liability for employers, which meant that employers were paid much bigger bucks for pain and suffering and also for the injury. And it was put in place ages ago so that employers would have more certainty. That is, they would know what premiums were rather than facing the uncertainty of these tort lawsuits that could come if someone were injured. So while you're not paying workers' compensation premiums on an independent contractor, you are also not receiving the protections of workers' compensation coverage on a bona fide independent contractor. A court may well rule that the person is an employee and is to be covered regardless of what you have called them after they go through some version of the IRS test, or another test that is sometimes applied is the economics reality test, which looks at kind of the totality of the circumstances and usually results in a finding that the worker is an employee rather than an independent contractor. It is also possible, as a practical reality, that a person is happy to be called an independent contractor until they find out that they can't collect unemployment compensation, or they can't collect pension benefits, or they aren't eligible for 401k benefits, which was one of the triggering things in the Microsoft suit. Additionally, it may come up within a Social Security context, because many of you are aware that most employers are paying into Social Security, and if a certain number of quarters are not paid into Social Security, there may be a problem with eligibility there. There may also be a concern with FLSA, which is the abbreviation for the Federal Fair Labor Standards Act, wage and hour law, or the equivalent state coverage of wage and hour law, or for coverage under Title VII against discrimination, or for related state laws about discrimination. It may come up within the context of an IRS, an FLSA, or a UC audit of the employer's books. I know we have seen situations in which state auditors have come in and questioned every 1099 that an organization filed, saying that they couldn't be independent contractors, that they were really employees. Sometimes this is in a little bit strange context, like estate administrators who are not even employed, for example, by a law firm. So again, we see that bent of federal and state agencies, that they really consider most people to be employees because that's the run-of-the-mill that's what they are more used to. We talk quickly about a claim for wages made under FLSA or state law, and that's clearly one possibility. That's going to be the coverage mechanism the person must be employed. It will often arise in the context of a contested discharge. That is, a person is not pleased that their services were terminated, and they realize that in order to receive some statutory protection, unemployment comp, workers' comp, discrimination protection for a protected class, including disability or age, that they have to be an employee in most circumstances. There can also be a question of tax deductions and whether or not it's appropriate if the person is an employee versus an independent contractor. Personally, I think the next is one that is going to be out there and looming even larger in the future. The count for Obamacare to determine whether or not you are a large employer or a small employer is a complicated count based on hours worked by full-time equivalent employees. Obviously, if you have treated a lot of folks as independent contractors rather than employees, there is going to be a problem with the count that is going to lead not only to the potential for tax penalties, but also to the potential for penalties under the Affordable Care Act or under Obamacare. You also want to check your own state laws to see what is out there that may apply to employees and not independent contractors, because if your state has some other guarantee or protection, that may come up. It may come up now in the context of family medical leave, again, which is available only to employees, not to independent contractors. As a practical reality, an employer can ask independent contractors for a copy of their business license, their corporate statements, their fictitious name statement, for example, that may be filed with a state government agency, business cards, certificates of insurance, all of these as indicators that a person is truly an independent contractor. If a challenge is made, it's nice to have a file of that type. It used to be one of the things that we would ask for was letterhead and business cards. In this day and age of the internet, however, those are less helpful than they had been because virtually anybody can create those rather quickly, and it really doesn't indicate a lot of forethought. We can now look to things like update with LinkedIn or other electronic listings or websites. And again, if a question arises, I would suggest that you do a little bit of research on your own and have that information available. If the person is indicating that they are providing computer services to a whole array of individuals and persons out there, you want to have that available as some indicator that they are doing that as an independent contractor rather than an employee. I want to take a minute to talk about the Pennsylvania unemployment compensation law, because I think that is something that is worth talking about for you, and it's a good example. The PA unemployment compensation law requires that for a person to be treated as an independent contractor, specifically the language is to be excluded from the definition of employment, the person must be free from direction and control and must be customarily engaged in a trade, occupation, or business that is independently established. So you can see that that's not an easy test to meet. We can argue that the first 3 IRS tests or that the 20-factor IRS test all fits within number 1, that the person is free from direction and control, but that you still have to meet the second prong of the test. Pennsylvania unemployment comp law is based on federal law, the Federal Unemployment Tax Act, or FUTA, and many other states follow similar requirements to that law, so that's something that you should take a look at and be aware. The bigger point I want to make to you is that sometimes just meeting the IRS tests is not enough. There is also some indication in the case law that non-compete provisions may defeat independent contractor status. That is, if you say somebody may not work for somebody else for X number of years or within so many miles after they leave your employment, that is a problem because independent contractors by their nature work for lots of people at lots of times. That is not a universal rule, but I point it out to you at least as a possibility so that you are aware of it. Again, under Pennsylvania law has been so concerned about misclassification that in 2010 they made an attempt to do what they call level the playing field, and they said that they passed the Pennsylvania Construction Worker Misclassification Act. Under that act, if an entity receives an advantage in a bid process, there are very specific penalties. Because if you think about it, it's probably cheaper for an entity to provide independent contractors than it is for an entity to provide employees. It's not uncommon for employees to receive a 30 to 40% benefit package on top of whatever their hourly or salaried compensation is. So you can see that that could be a significant savings. So the Pennsylvania legislature tried to eliminate that through passing the Pennsylvania Construction Worker Misclassification Act. Again, for those of you that are not in Pennsylvania but are outside of Pennsylvania, you want to be aware of whether or not there are quirky laws like that out there that may affect you as well. And one of the things that we have added to our HR personnel policies and procedures book is a listing of quirky Pennsylvania laws that you may wish to be aware of. One of the others, for example, had the governor told people to stay off the roads during this snow emergency in Pennsylvania, and he did declare an emergency, but he did not tell people to stay off the roads. You could not have terminated people who refused to come to work during that period of time. So each of the states has some quirky little laws like this that you must be aware of in order to protect the entity that you are working with. There is congressional scrutiny out there. I referred to the Department of Labor's use of the term fissured workplace that they have been using since 2008. To me, it's a complicated term, but they are becoming more and more concerned that the place that a person goes to do their work is not the person they are working for. So they work for a temporary service and yet go to work with Microsoft and think that Microsoft is the employer when Microsoft is not, but the temporary service is. We could make some argument that the same sort of thing could happen occasionally with independent contractors, although often independent contractors are not required to go into a workplace any number of times to provide the service that they are providing. Sometimes they must to observe things, but sometimes they can do the work at a totally separate or remote location and not be in the workplace. Okay, we have covered a lot of material, and before I go into the conclusion, I do want to address a question that came in before the seminar started about whether or not musicians, it looks to me like the musicians provide the service for a church, are to be considered as independent contractors or employees. And let's use that as a little bit of a recap. To begin with, you have church services, I suspect, which means that the church is providing and directing the times when the physicians must be there. On the other hand, I presume that the musicians are providing their own instruments and that the church is giving very little direction about how the musicians play, although the church may be selecting the music that is used. I would want to go back and find out whether or not those particular employees, because I think they worked only a few hours a week, and I said particular employees, let's change that to particular workers, work a lot of hours for that church, or whether or not they work for a number of other entities. You want to find out whether or not they hold themselves out to the general public, as we talked about. I did a little bit of case research and interestingly found a number of just a couple cases in Pennsylvania that are old cases in which the courts, as anticipated, found out that musicians for a restaurant and another set of musicians were considered as employees rather than independent contractors. And again, that's the default that most courts and most administrative agencies are going to find. So I'm not saying absolutely these people are employees, but I would suggest that you go through that 20-factor test and figure out where the right to control lies, and also look at which factors favor employment, which factors favor independent contractor, and then perhaps we could have more communication by email after the seminar ends, either today or some other day. Let me go back into the conclusion, or the final 5, if you will. There is no bright line test to tell you whether the worker is an independent contractor or an employee. It just doesn't exist. If you want to draw a very bold line on a page with your Sharpie or whatever, with your magic marker, that isn't what we're dealing with. Instead, draw a very wavy line and you've got more of what we're looking at. Each determination, secondly, is highly, let me emphasize highly, fact-specific, and the analysis may differ because of state statutes, state laws, and we talked about that a little bit with the unemployment compensation law, with the worker misclassification law. So there can be variations among states. And let me catch up with the slides, I apologize. Specific statutes redefine the terms for specific purposes. Statutory definitions of these terms appear to be increasing rather than decreasing, and I think with that increase you will find out that more persons are considered to be employees, because as a public policy we want employees, we want people generally to have more and more protections. Employers should not classify persons as independent contractors if the employer wishes to retain the right to control that person. Let me also add that an employer should not classify a person as an independent contractor just because the person wants it, because many of the penalties will be against the employer. And for example, the Social Security Administration can recover from the employer both the employee and the employer share of Social Security, in addition to a number of other penalties and the interest that has accrued on the amount that has not been paid. A careful employer who properly utilizes independent contractors will find enhanced flexibility to meet his or her workplace needs. Again, I will emphasize that this is less important if there is a corporate shell, because it is much easier to hire another corporation, another business to provide services for your entity than it is to hire a person to supply those same services. So you'll find that many employers have a list of vendors that they work with, and the vendors supply things, and that's perfectly appropriate. And then the vendor becomes the employer of its own employees, and generally you do not. So a careful employer is going to look at all of this and determine what makes sense for it to use. There is no substitute for determining in advance of hiring in advance of bringing the person in to provide services for you, whether or not that person is truly an independent contractor or an employee. Okay, I am at a point where I am ready for questions if you have some. I know we've covered a lot of information. I certainly hope it has been helpful to you, and I thank you for not only your participation, but for what I hope is going to be a number of questions that will follow now. Eric?
Yeah, Kathy, we did have a couple questions come in here, so I'll just read them off to you. The first one is from Stephanie, and she says, my New Jersey company hires Canadian nationals as sub-consultants to do work in our Jersey office. Usually I require a W-9 and insurance comp. Are they exempt from those requirements due to the North American Treaty?
I will confess that that one is outside of my wheelhouse. I am not aware of an exemption that applies, but I have not looked at that specifically. That's one that I would want to have you discuss with counsel who is more familiar with that treaty and also for the way they are being employed or being utilized. The word sub-consultant is, in my estimation, not an accepted term in the case law. So I've got some red flags going up, but that's one that would take more research than I have done at this point in time. I've just been dealing with it domestically. I have not had to deal with it with foreign nationals, but I believe that since the foreign nationals are performing the work here, that by and large law would say that most of the protections, the discrimination protections and such, would apply. So that could be a naughty situation, and it's one that should be discussed specifically with counsel.
Okay, sounds good. And Stephanie, if you have more questions, we'll get Kathy's email up, and you can follow up by email if you want more info from her or she can help. Then we had another question from Stephen, and Stephen said, if a healthcare provider hires a temporary staffing agency for nursing, the understanding is that it is an independent contractor relationship. However, I do not think the temp employees working alongside employees will meet these tests. Comments? Is that clear to you, Kathy?
That is another naughty situation that seems to me to be very similar to the Microsoft situation. I do not believe, based on what I'm hearing, that those people are independent contractors. I do believe that they are employees of the temporary service that they're working for, but there is also, in my mind, a high probability that those folks are also potentially joint employees of both the healthcare institution and the temporary service. And there has been new guidance on that within the past 2 weeks. So that's an area that is definitely evolving, and that to me signals caution, Will Robinson, because I think that's the problem area. If you have not discussed that with your in-house counsel or don't have in-house counsel available, I think you should seek additional guidance on that, because I don't think they're going to meet an independent contractor test if they're doing the same things that your employees would normally be doing. Now, if it's a healthcare agency that's bringing in somebody for computer services only, that's something different, but I'm hearing this as a temporary agency that's supplying either more aides or temporary nurses or folks that are really doing things that are of the ilk that the healthcare institution does.
Okay, that's all the questions we have for now. I'm putting Kathy's information up on the screen. So go ahead and write down her email if you'd like it. Feel free to enter any questions as we do the announcements at the end here. Here are your SHRM and HRCI activity numbers, so go ahead and take those. Kathy, I just want to thank you for coming on and speaking today and giving a great presentation. Really appreciate it.
And I'd like to thank everybody that participated, and you as well, Eric.
All right, thank you. Okay, yeah, I'm not seeing any other questions here. Kathy, do you have any final words?
I just want people to understand that one size does not fit all on this. You really have to go through the effort of going through the tests in each situation to figure out what the result should be. And this is one we're trying to shove a square peg into a round hole is probably going to result in trouble for you, either from the IRS or other agencies. Again, my thanks to the folks who are interested enough to check this out up front.
Okay, all right. Well, thank you for coming on. Thanks for everybody for attending. I'm going to go ahead and wrap it up on behalf of HRSimple.com and SkarlatosZonarich. Thank you for spending time with us today, and we hope you'll continue to learn with us throughout the HRSimple.com webinar series. Have a great day.